I have been on the bench long enough to know the difference between confidence, arrogance, and contempt. Confidence answers questions. Arrogance argues with facts. Contempt walks into a courtroom believing the law is a service available for purchase. Julian Sterling was contempt in an Italian suit. The moment he entered my courtroom, I knew I was looking at a young man who had spent too many years confusing inherited wealth with immunity and money with moral authority. The case looked like a traffic matter on paper, but the details made it something else entirely. Julian Sterling, 21 years old, heir to a hedge fund fortune, had been charged with reckless endangerment, destruction of private property, leaving the scene of an accident, and attempted bribery of a public official. According to the report, he had crashed his $2 million McLaren into a retired janitor's Honda Civic, injured the 72-year-old driver, then threw cash at him and told the responding officers to make the problem disappear. The injured man was sitting quietly in the front row when court began. Arthur Miller, 72, retired janitor, left arm in a sling, face bruised, hat clutched in both hands. He looked like a man who had worked his entire life, followed the rules, and then been taught in one violent moment that somebody richer believed his life came second to a luxury car and a dinner reservation. That kind of humiliation has a shape, and I could see it on him before anyone spoke. Julian, meanwhile, strutted in as though he was hosting an event. 5 lawyers, 4 security guards, sunglasses indoors, gum in his mouth, smirk on his face. He did not look like a defendant. He looked like a man arriving to buy the building. When I told him to remove the sunglasses and put away the checkbook he had already pulled from his jacket, he did take off the glasses, but he left the checkbook right there on the table and opened it like we were discussing catering, not criminal conduct. Then he tore out a check for $50,000, slid it toward the bailiff, and announced that it would cover the old man's car, medical bills, and a donation to the police charity of our choosing. He said if that settled everything, he could still make his flight to Saint-Tropez. That is not restitution. That is bribery with a smile. His lawyer tried to dress it up as a settlement offer. No, let us all be adults. A settlement is negotiated through lawful channels. This was a live attempt to purchase the court in open session. Worse, Julian genuinely believed it should work. He did not whisper. He did not hesitate. He said everyone has a number. Then he asked whether mine was higher. That was enough for me to understand the whole shape of the boy. Not just spoiled, trained, raised in a world where every door opens if enough zeros are attached to the request. So I had the check seized as evidence, and I moved the case forward immediately. The prosecutor called Arthur Miller first. Arthur testified quietly. He said he had the green light. He was coming home from the grocery store. Then he saw headlights moving too fast to make sense on that street. The impact spun his car and left him trapped, bleeding, unable to move his arm. He said Julian got out of the McLaren, looked at him through the broken window, and instead of calling for help, threw cash at his face and told him to buy a new life. Then he walked away. I have heard many ugly things in a courtroom, but what mattered just as much was what happened next. Julian laughed. Actually laughed. He said Arthur should be grateful because the Honda was junk and the crash had upgraded his life. Then he mocked Arthur for taking the bus with his wife to dialysis. That was the moment the room changed. Not because of me, because everyone there could suddenly see that this was not youth, not nerves, not a careless moment. This was worldview. To Julian Sterling, human suffering was a line item. Inconvenience was for other people. Public streets were personal racetracks. An old man's pain was just part of the cost of moving too fast. So I questioned him directly. He admitted he paid tickets the way other people pay tolls. He described fines as service fees for driving how he wanted. He said he created more value than most people in the room ever would, and that time spent in court cost him more than Arthur Miller's car was worth. Then, in front of everyone, he threatened to have me removed if I did not take the money and end the case. Now let me explain something very clearly. Courts do not exist to flatter wealth. They exist to remind wealth of its limits. A fine can punish a working person. To a young millionaire, it can become permission. So I refuse to turn justice into a transaction. I found him guilty of reckless endangerment and destruction of property. I found him guilty of attempted bribery of a public official and intimidation of a judicial officer. Then I sentenced him to prison. No fine, no donation, no special arrangement. Prison, because the only thing Julian Sterling valued was freedom, and that was the only consequence he could not treat like a luxury surcharge. The handcuffs went on, and for the first time all morning, the smirk vanished. His father spent millions appealing. It failed. Arthur Miller's community raised money for a new vehicle and his wife's care. And Julian learned the lesson his family had spent 21 years protecting him from. Money can buy lawyers, it can buy cars, it can buy watches, bodyguards, and very expensive bad manners. But it cannot buy dignity, and it cannot buy the law if the people inside the courthouse still remember what justice is for. That is the whole lesson. Inheritance is not character. Wealth is not innocence. And in my courtroom, if you try to put a price tag on justice, you are going to learn something priceless the hard way.